Hi, I'm Alabama criminal defense attorney Andrew Segal of Segal & Segal. Today what I want to talk about is what you need to know if you're accused of rape in Huntsville, Alabama. The first thing you need to know is that there are different types of rape. We're going to talk about rape first degree and the ways that crime can be committed, and then we're going to talk about rape second degree and the ways that crime can be committed. Let's start with rape first degree. There are three ways that the crime of rape first degree can be accomplished. The first is if the accused person has sexual relationships with another person by what's called forcible compulsion. Basically that means that they're having sex with another person against their will and that it is forced. The force can be accomplished in any number of ways. For example, the most obvious is if a guy says, look, I got a knife, I'm going to cut you if we don't have sex, or I got a gun, I'm going to shoot you, or something like that. And the person says, okay, that's rape first degree. There's other, a little bit more subtle. If the fellow, he doesn't have to have a knife, he doesn't have to have a weapon of any kind. He can just say, better do it or I'm going to hurt you. That's rape first degree too. You can even say, I'm going to hurt you, or I'm sorry, he can even say, I'm going to go hurt your cousin unless we have sex. Again, the threat doesn't have to be to the person, it just has to be that the threat doesn't have to be to the victim is what I'm trying to say. It just has to be that a threat is made that causes a person, the victim in this case, to give up and be willing to have sex because of some degree of fear inspired by the threat. So that's one type of rape first degree. The other type of rape, so going back to that, it's an express or an implied threat. It doesn't even have to be words, but if there's a threat. Let me get back on target here. The other type of rape first degree can occur when the victim is either physically helpless or mentally incapacitated. So let's talk about those things. Physically helpless, if a person was handcuffed or tied up or in a coma or in a wheelchair or any circumstance where they're physically helpless and they are unable to give consent and another person has sex with them, that's rape first degree. The other type of rape first degree, or one of the other ways of that, is if the person is mentally incapacitated. Later on I'll talk about a different kind of rape where the person is mentally defective. Right now I'm talking about if the person is mentally incapacitated. Rape first, when somebody's mentally incapacitated, means that the victim has, not through their own efforts, but has been basically given some sort of a drug or an intoxicant or something where they are incapable of controlling their conduct as a result of this. So this is the kind of sex crime that Bill Cosby was accused of. Women said, oh, he slipped something in my drink. I was out of it. I woke up, he had raped me. Or I woke up and I believed he had raped me. So if if a fellow slips something in a girl's drink and she loses it, she no longer has the capacity to consent, and he has sex with her, that's rape first degree also. Those types of rape, either by force or somebody who's physically incapacitated or mentally incapacitated as a result of drugs, carry a range of punishment of minimum of 10 years in the state penitentiary, maximum of life or life of life or 99 years in the state penitentiary. There's a third type of rape in the first degree, and that is when a person who is above the age of 16 has sexual relationships with a child who is less than 12. If the victim in the rape case is under 12 years old, that's also rape first degree. The punishment is even more severe for that. The minimum punishment for that type of rape is 20 years in the state penitentiary. The maximum, again, is life. So, in a nutshell, those are the types of rape first degree. Now let's move on. Now we're going to talk about rape in the second degree and the ways that that particular crime would be committed. Rape in the second degree, there's two basic types. The first is what we commonly talk about as being statutory rape. The law can get a little bit confusing to people on that, but statutory rape, it doesn't matter if the person, consent is not an issue. In other words, the girl can be fully consenting. She can be ready, willing, and able. But the law says that because of the age, she is not allowed to give consent. So let's talk about that a little bit more, because that's a not uncommon kind of rape charge. That occurs when a person who is at least 16 years of age, or older of course, has sexual intercourse with somebody who is between the ages of 12 and 16. In other words, I think that's a little bit self-explanatory, but here's where it gets a little confusing. The state has to establish that there's at least a 2-year age difference between the person who is accused and the victim of the crime. So to put it in perspective, if a person who is, how should I put it, if a person who is 14 years old has sex with her 16-year-old boyfriend, that would not be a statutory rape case as long as that 2 years. In other words, if it's a full 2 years. If he's 16 in a day, it is. But if there's 2 years or less, then it is not rape in the second degree. That's not to say that the woman may not claim that it was forcible or some other kind of rape, but on that basis, the age basis, that would not be. If the guy is 17 and he has a 14-year-old girlfriend and they want to get married and they get too amorous and they have sex and mama and papa find out, that's rape, and that is rape in the second degree. There's another kind of rape in the second degree, and that occurs when a person who is mentally defective has sex with somebody else. In other words, a person who is mentally defective, and I'm not talking about, as I talked about earlier, somebody who's mentally incapacitated as a result of some sort of drugs or something like that. This is somebody who has some sort of a mental defect, maybe they're mentally retarded or some other mental health issue where they're not able to give consent. Somebody who has sex with a person who is in that mental state, who is mentally defective, is committing a crime, and that crime is also rape in the second degree. It's just a variant of that. Typically, the range of punishment for rape in the second degree is from 2 to 20 years in the state penitentiary. If the victim is a child, though, then the range of punishment can be 10 to 20 years. All of these cases, of course, are fact-specific, and I want you to be aware that just because you're watching this video doesn't mean that the law hasn't changed. I'm recording this on a specific date and time. The laws are constantly evolving and changing. You also need to know that just because you're watching this video doesn't make me your lawyer, of course. Now, I want to move on to another subject, which is what happens for somebody who is convicted. Well, let's say somebody is convicted of one of these crimes and they either have done their time, or in the alternative, they were lucky enough to avoid actual imprisonment. Once somebody is convicted of a sexual offense, Alabama has laws called the SORNA laws. SORNA stands for the Sex Offender Registration and Notification Acts. What it means in a nutshell, and the actual laws are very, very long and very complicated, but what it means is that the person who is convicted has to be registered with law enforcement as a sexual offender, and it means that the public notification provisions typically will kick in. There may be some exceptions in certain circumstances, but typically those are going to kick in. So that means they also can't live in certain areas because the laws require that they don't live within a certain distance of a school or a housing project or other things. Also, those laws apply to who they can or can't live with. So a person who is convicted of a sexual crime, even when they're done with whatever kind of direct punishment, has many other consequences, and in fact, if they don't comply with the sex offender registration laws, they can be charged with new criminal offenses that could put them back in prison because they didn't comply with those laws. Needless to say, if you or somebody you love is accused of rape or any kind of sexual crime for that matter, you need to talk to an attorney as quickly as you possibly can. Vital that you do so. If you can't afford a lawyer, you need to talk to the judge and ask for a lawyer to be appointed for you. If you don't have a lawyer and you're lawyer shopping, obviously we're happy to talk to you. If you want to give us a call, you can. Our feeling here at Segal & Segal is that you shouldn't have to pay for your first consultation. And the reason for that is that we feel that a person ought not have to pay to decide if they want to hire a lawyer. Also, the other reason is that we want to evaluate a case and see if we're willing to accept a case. If you talk to us or any other lawyer, when you talk to them, the conversations you have with them are completely confidential, and that's by law. A lawyer cannot tell somebody what you've said. That's a violation of their ethical rules. We have to basically keep it in the office. It's like the Vegas thing. Whatever is said in a lawyer's office stays in a lawyer's office. So if you want to give us a call, feel free. Our number is 256-533-4529. Again, I'm Andrew Segal of Segal & Segal, and I hope this video has been informative and helpful to you. Thank you for watching.